Welcome to POSH Deep Dive, a series that goes beneath the surface of India's prevention of sexual harassment law. In every episode, we explore the real meaning behind the act. Come, let's listen to one story, one deep dive at a time.
Welcome back to the Deep Dive. Today, we are cracking open really one of the most high-stakes documents in any organization, the Essential Guide for Internal Committees, or ICCs.
That's right.
These are the committees conducting inquiries into workplace sexual harassment, usually under POSH guidelines. And this isn't just some HR rulebook. It's basically the playbook for a quasi-judicial process. The outcome can define or, destroy a person's career and reputation.
That's the absolute truth. You've hit the nail on the head calling it quasi-judicial. The ICC's role is huge because they aren't just dealing with policy stuff.
Sure.
They're running an impartial investigation, and it has to stick really closely to the principles of natural justice. They actually have the powers of a civil court.
Wow.
And the stakes just couldn't be higher. You have to remember, a wrong decision can genuinely ruin a person's family life, their reputation, if they get wrongly disciplined.
So our mission today is really to pull out the practical rules, the key deadlines, and maybe most importantly, the philosophical foundations guiding this really sensitive process.
Yeah.
We need to understand how an ICC actually moves from a complaint to a finding, all while keeping fairness, right at the core.
Yeah.
Let's start with the thing every committee hates. The ticking clock.
Exactly. When that process starts, time is, it's the first major guardrail.
Okay, let's unpack this. When a complaint actually lands, how long does the ICC have to get the investigation done? Because these things need closure, right? Not just for the company, but for everyone involved.
Yeah, they absolutely cannot drag on. The Act mandates that the ICC must complete the entire inquiry process within a pretty strict window, 90 days.
90 days, okay.
And if for some really justifiable reason that timeline has to be pushed, the delay has to be thoroughly documented in writing, justified clearly, and it needs to be available for checking. The rules see missing that deadline as a serious accountability issue.
And accountability, that starts with fairness, right? How does the ICC make sure they are impartial when one person has made such a serious accusation?
The guidance is very explicit on this. The ICC must be unbiased, neutral, and broad-minded. They have to treat both the complainant, the victim, and the person accused, the respondent, with equal respect and dignity.
Okay.
This is just non-negotiable because right at the start of the inquiry, you have to assume innocence holds true. Like the guidance says, no one is yet proven guilty.
That makes perfect sense for, maintaining due process. Yep. Now, let's talk about legal procedure in this.
Right.
Well, it's not quite a courtroom setting. If it's so complex and high stakes, can people bring lawyers?
So this is one of the most distinctive things about the ICC setup. And it often surprises people. Legal counsel for the parties involved, ordinarily not envisaged. And in fact, it's not permitted during the ICC hearings themselves.
But wait a minute. If you bar lawyers, aren't you maybe putting someone who isn't great at arguing their case or isn't powerful at a huge disadvantage facing this kind of quasi-judicial investigation?
It's definitely a tension, right? It's inherent in the system. I think the intent is to keep the process, informal enough to encourage people to actually come forward without turning the whole workplace investigation into a full-blown court battle.
Okay.
It sort of prioritizes finding the truth over, legal gamesmanship. The idea is the ICC's own training should make up for the lack of lawyers.
Is there any exception, for support?
Yes, but it's tightly controlled. On a case-by-case basis, the ICC might allow a complainant to be accompanied by someone, but strictly for emotional support.
Oh, okay.
And that person absolutely cannot be a lawyer, and they're explicitly barred from speaking or participating at all during the proceedings. It's purely about having a supportive presence.
You mentioned the ICC having civil court powers. What does that actually mean practically when they're holding these hearings?
Well, it gives them immense leverage to gather evidence. They have the power to summon people and force their attendance employees, outside witnesses, anyone.
Right.
And they can examine them under oath. They are set up to be serious fact finders.
And what if one side just decides, nope, not showing up? What happens then?
The ICC has a clear way to handle that, to prevent stalling tactics. If either the complainant or the respondent fails to appear for 3 consecutive hearings.
3, okay.
3, yes. And they don't provide a good documented reason. The ICC has the right to either terminate the proceedings entirely if it's the complainant who's not showing,
right,
or deliver an ex parte decision.
An ex parte decision that means ruling based only on the evidence from the party who did show up, yeah.
Precisely. It means the ICC just moves forward based on one side of the story. It's a pretty crucial procedural penalty to ensure people comply and don't sabotage the process by just not turning up.
Okay, that procedural strictness leads us now to the real heart of it, the kind of philosophy behind the judgment. Once the clock's ticking and the rules are set, how does the ICC actually define harassment? How do they confirm it happened?
Yeah, this is where they shift gears a bit from procedure to, well, almost psychology. When they're looking at a claim, the ICC has to figure out three key things. They're essentially asking, first, is the harassment actually sexual in nature? Second, was the behavior unwelcome and unwanted by the person experiencing it?
In a welcome part.
And third, what was the victim's perception or interpretation of what happened?
That second and third point, the subjective nature of it all, that must be incredible.
That standard is the tool they use to avoid making findings based just on, say, individual hypersensitivity, or, on the other hand, total denial from the respondent.
Tell us more about this reasonable woman standard. What does it actually require of the behavior? What does it mean?
It basically defines conduct that a hypothetical reasonable woman would find severe enough or pervasive enough to fundamentally change her conditions of employment, to create an abusive, hostile work environment.
Okay.
It forces the ICC to step outside of the respondent's intent, what they meant to do, and focus squarely on the impact, viewed from a kind of normative, gender-aware perspective.
This feels critical because, as you said, the source material points out there's often a huge difference in perception between genders about these interactions.
Absolutely. The guidance specifically highlights that. It says many men often see certain forms of sexual harassment as just, harmless social interactions, or maybe objectionable, but not serious.
Right.
But the exact same behavior is often perceived by many women as deeply offensive, invasive, and, environment altering.
Can you give us a concrete example, something that shows that difference in perception in the workplace?
Sure. Think about a male supervisor telling a female subordinate she has a great figure or nice legs.
Okay.
Now, the supervisor might genuinely think he's just giving a compliment, a harmless social interaction in his mind. But the female colleague might feel it's invasive, totally inappropriate, maybe undermining her professional standing. It could change her whole experience of coming to work each day.
So the ICC can't just look at the behavior in a vacuum. The determination always has to consider the overall context and is made case by case, but grounded in that reasonable woman perspective.
Precisely. It requires the committee to look at the totality of the circumstances, not just one comment pulled out of thin air.
Okay, the philosophy seems set, but getting the actual evidence, that sounds like a minefield, especially if victims are reluctant. The guidance says the ICC needs to use compassionate listening. Why is understanding those fears so vital for a full investigation?
The guidance is really explicit about the deep social and economic fears that often lead to silence. The ICC has to understand they're not just getting a statement, they're hearing a story that's potentially wrapped in immense personal risk.
What are some of those key fears the committee needs to be aware of?
They are heartbreakingly specific, actually. There's the fear of family judgment, the worry that their own family might ask, well, didn't you invite it yourself?
Oof.
Yeah. There's the deep, basic fear of losing their job, economic vulnerability, or just being labeled a troublemaker forever in that workplace.
And beyond the social risks, you mentioned legal risks too, which are huge now.
Absolutely. A major chilling factor is the fear of a retaliatory defamation suit. The harasser sues them. Suddenly, the victim becomes the defendant.
Wow.
And often victims carry this immense guilt, believing they must have done something to cause the incident. The ICC needs to navigate all those layers, internal and external pressures, really compassionately.
And as the investigation moves forward, confidentiality must be hard to maintain, right? Which adds another layer of vulnerability.
It really does. Once an investigation is formally underway, even with the strictest rules, basic facts can sometimes leak. And that can lead to more embarrassment, maybe harassment from coworkers or even management.
Given these high stakes, especially if the case involves senior or, really influential people, how does the ICC protect its witnesses?
This needs extreme vigilance from the committee. If the alleged harasser is in a position of power, the ICC absolutely must set up and enforce safeguards. They need to protect witnesses from any kind of intimidation or pressure. Their job is to make sure it's a safe space for evidence to emerge.
Let's talk about the evidence itself. If the ICC acts like a civil court, what if they can't get every single piece of paper they ask for? Does the whole thing just collapse?
No, and this is where pragmatism comes in. The guidance advises that just because a few documents are missing or unavailable, it doesn't necessarily invalidate the whole ICC process. It doesn't derail it. The key principle is, if there's enough material evidence found overall, the strict procedure or form might be dispensed with. Substance over form, essentially.
Right. That leads to a really crucial point about evidence and character. You often hear respondents try to defend themselves by saying the complainant is generally flirtatious or maybe uses foul language sometimes, suggesting they couldn't really have been offended by this specific conduct.
Yes, and that's a fallacy the ICC must explicitly guard against. The guidance is crystal clear on this. It is wrong to conclude that someone's past conduct, even if they use sexual innuendo in a totally consensual setting before, means they welcome the conduct in question from this specific alleged harasser.
So an employee being willing to joke around or flirt with one person.
It absolutely does not mean they have to accept the same thing from everyone else. An individual always obtains the right to choose who they engage with and how. The inquiry has to focus only on whether they welcomed the specific conduct from the specific respondent in that instance.
That is a vital distinction.
Okay. A really vital distinction for any committee member to keep in mind.
Moving to the integrity of the committee itself. Conflicts of interest. How strict are the rules there?
They have to be avoided completely, really, to protect the final finding. An investigation team member should not be directly or indirectly related work-wise or personally to either the victim or the alleged harasser.
Makes sense.
So, for instance, if an ICC member reports directly to the person being accused, they cannot be on that inquiry team. It's a clear conflict.
Right.
Also, the complaint has to be heard by the ICC as a whole team, not by individual members just doing their own thing.
Okay. We established the ICC can use cross-examination if needed. But the source material has this really fascinating legal exception, touching on the principle of natural justice itself.
Yes, and this, I think, really highlights how the system sometimes shifts from a purely adversarial process towards prioritizing psychological safety. While cross-examination is usually seen as a right, the guidance notes that in cases involving grave circumstances, denying cross-examination is actually legal, and it does not violate the principles of natural justice.
Wait, hang on. So the basic procedural rule of natural justice, the right to face your accuser, challenge their testimony that can be overridden here by the need for psychological safety. That sounds like a massive shift in legal priority.
It is a critical insight into the system's mandate. The justification given is that in highly sensitive situations, it's considered potentially hazardous to expose particularly vulnerable women to what they call the tardy or aggressive process of cross-examination. It's basically an acknowledgement that strict legal procedure in some contexts could actually inflict further harm.
That's, wow, a fascinating procedural allowance, specifically designed to protect the vulnerable party. Okay, finally, the ICC's job doesn't just end when they file the report, right? What about after the inquiry? Protection.
Absolutely. The ICC must ensure there's no retaliation back in the workplace after the findings are submitted. And this protection extends to the victim, obviously, but also to the alleged harasser if they were cleared, to make sure management, supervisors, colleagues don't take any negative action against them either.
And what if the alleged harasser turns around and files their own complaint against the original complainant?
The ICC has to deal with those cross complaints too. They need to do a really careful evaluation to figure out, to distinguish whether these new complaints are actually genuine issues or if they're purely retaliatory in nature.
Right. Trying to punish the person who complained first.
Exactly. And throughout all this, the documentation has to be meticulous, clearly specify charges, complete paperwork, signatures, and then the final report needs clear findings and recommendations for what should happen next.
This whole deep dive really shows the internal committee is this truly hybrid entity. Its members need to be strict proceduralists, but also empathetic listeners and objective judges of human interaction all at the same time.
That really is the ultimate tension, isn't it? They have to balance these rigid, legally required principles of natural justice and due process, which demand fairness for everyone involved, with the unique sensitivities demanded by the reasonable woman standards and that mandate for compassionate listening. They're basically asked to prioritize context and safety while wielding the authority of a civil court.
It's an immense responsibility. So here's a final thought for you, the listener, to mull over. Considering the ICC is armed with civil court power, yet is mandated to bar lawyers, and has to rely so heavily on the reasonable woman standard and compassionate listening, What does this tell you about how modern workplace jurisprudence might be prioritizing psychological safety and contextual investigation over purely adversarial legal procedure? Something to think about as you consider just how complex due process can be.